Mr. Ament, we welcome you this morning and look forward to hearing your opening remarks.
Justice Wiggins, members of the commission, good morning.
Morning. Morning.
Thank you for your time. Your service to the state of Iowa is to be commended. My name is Craig Ament. I have been an attorney for nearly 31 years. I have been in private practice for nearly 27 years and a solo practitioner for the past 15 and a half. My wife Laurel has accompanied me here today. She and I have been married since 1983. We have lived in the same house in Cedar Falls since 1995. Laurel is a registered dietitian and has worked for Covenant Medical Center since 1985. She also consults privately for a nursing home. We are in the process of dealing with an empty nest. Laurel and I have two bright, ambitious, hardworking, beautiful daughters, Katerina and Deanna. Katerina graduated from the University of Iowa this past May. She earned a Bachelor of Science degree in psychology. She is working as a research assistant for a psychiatrist at the University of Iowa Hospital and is scheduled to give a presentation based on her work at a seminar in Texas in March. She is in the process of applying for graduate PhD programs around the country. Deanna is a sophomore at Iowa State. She is just 19. She was accepted into the architectural program this past summer. She plans to add a minor in engineering or in business administration. Laurel and I couldn't be prouder of Katerina and Deanna. Becoming a Supreme Court justice is something I have always dreamed of. In the way one dreams of becoming an astronaut or climbing Mount Everest. Possible, but shunted aside to take care of the obligations of life. After last year's elections, I really started to think about that dream. But it is one thing to pursue a dream and another thing to tilt at windmills. It is easy to look at oneself through rose-colored glasses, but I did not want to be the American Idol candidate whose aspirations far exceeded his grasp. I talked with members of the bench and bar whose opinions I trust and tried to critically examine my body of work. It has been quite eclectic. I prosecuted. As a prosecutor, I tried everything from OWIs and indecent exposure to willful injury and burglary. One of my juries returned a guilty verdict on a rape case, the first time that had happened in Clinton County in more than a decade. I second-chaired a murder and retried another well before I was 30. In private practice, I have represented plaintiffs and defendants, but I haven't done any insurance defense. Most jury trials were either personal injuries or criminal defense. The criminal cases that come quickly to mind include kidnapping, burglary, rape, and murder. Non-jury trials have included complicated, lengthy dissolution trials, administrative law cases, post-conviction appeals, and even an age discrimination where my plaintiff was a 32-year-old woman. I believe in pushing myself, so 2 years ago I completed mediation training. My non-litigation clients are most often in corporate, business, and real estate matters. 3 of my last several non-jury trials were construction contract litigations. I haven't done a bankruptcy in years, and I do just enough tax to recognize a tax issue in those fields I do practice in. With regard to the appellate courts, I believe that the judicial temperament needed is not the same as that required of a district or associate judge. The Supreme Court is a court of last resort in Iowa. The cases the Supreme Court keeps, it keeps not because it wants to mete out justice to the individual parties, but because there is an issue which will affect more than the parties now and into the future. Most often, the court must resolve a legal issue, not a factual one, and in so doing, the court owes its allegiance to the law, the Iowa Constitution, and the Constitution of the United States. I have heard people say, the law is the law, but the plain and simple truth is, it is not. The law is a living, breathing, evolving thing. In 1839, in re the matter of Ralph, Iowa's first Supreme Court case, a slavery case, was cutting edge. Now it is relevant only historically. 100 years ago, women's suffrage was a hot topic. Now not so much. 30 years ago, a man's chance of obtaining custody in a dissolution was slim at best. The law evolves, and the court must recognize that evolution and face it head on. The court has a proud heritage, but times are changing, not only with the law, but with the administration of the law. I want to assure that my children and future generations of Iowa are left with a judicial system that they have the same access to and take the same pride in that I have. I believe I can offer the court common sense. Without it, we achieve absurd results. Mental focus. When I am focused on an issue, nothing can break my concentration. The ability to listen. It is important that both the advocates and the other justices' opinions are fully considered. The ability to come to an opinion and rationally and legally defend it. The ability to avoid preconception. The ability to change my mind. And the ability to write and convey my thoughts clearly and plainly. If nominated by the committee and appointed by the governor, I believe I can do the job. This concludes my opening statement. I would be happy to address any questions.
Thank you very much, Mr. Ament. Let's start on this side. Mr. Pace?
Thank you, Justice Wiggins. Good morning.
Good morning.
You said in your opening remarks that the law is a living, breathing, evolving thing. And there are a lot of folks watching this today, and I'd like you to explain what you meant by that and how the law evolves, how it should evolve over time.
We have as our core in the law two things. We have the U.S. Constitution and the Iowa Constitution. And their language and the precepts that those words describe are the anchor that we use to bring forth the law, the 6 volumes of the code we currently have here in Iowa, for example, the innumerable volumes of federal law. But in so doing with that law, the legislature sometimes is ambiguous or sometimes misses the mark. We have to recognize when that law follows both what the Constitution set forth as the foundation and where the path, frankly, of society is leading. I believe, for example, I mentioned suffrage. Over 100 years ago, the Constitution declared we had the right to vote for all men, and it was up to us to decide that what they meant was mankind. That's a process of evolution, but still anchoring yourself to the tenets that the Constitution sets forth, both Iowa's and the federal one. Have I answered your question?
You have, thank you.
Any other questions on the right side over there? Let's move on to this side. Mr. Cook.
Thank you, Justice Wiggins. Sir, in looking at your materials, I see that you disclosed you were a defendant in an action in Blackhawk County, and I don't mean to embarrass you by that. I have a question about the process and your qualifications.
Sure.
You indicate that the case went to trial in 2007. You received a directed verdict in your favor, and the case was appealed to the Iowa Appellate Court, and the Appellate Court reversed the verdict in your favor, and then the case was retried in February of last year, and a verdict was returned again in your favor. What did you learn about that process, or from that process, that relates to the appellate court function and what you would do if you were on the Supreme Court?
I learned that the appellate court doesn't always see things through the same eyes as the district court. I learned that the appellate court will often, at least in that case, sometimes, and second guess is not the right word, sometimes take a broader view of the issues than perhaps that the trial court does. The reason that the case was reversed is because the appellate court thought that there was sufficient evidence to submit it to the jury. The district court did not. So it was returned and retried. I learned of the whole process that in spite of the fact that the process can be tedious, unnerving at times, perhaps overly complicated, that in the greater scheme of things, it works, including the appellate process, which gave the plaintiffs, via the second chance, a full opportunity to air, litigate, and present and receive a jury verdict.
Thank you.
Any other questions to my left here? Mr. Mann, I do have a question. We know what happened in the last retention election, at least the end results were that 3 justices didn't get retained. But what do you think that was all about?
What I think it was about was that two things. I think you had a small core group of the population of Iowa that expanded through publication, media, and PR to convince a majority of the population that the Supreme Court of Iowa had exceeded its obligations and duties by legislating. I don't believe it was really about homosexuals. I believe it was a conception by the populace, because of the media that they heard, that the court had exceeded its boundaries.
If that's your take on it, what do you think the court needs to do to take care of that problem?
I believe that most of the lawyers understand and appreciate what the court does. But I believe most of the public sees the Iowa Supreme Court a little bit like most of us see the U.S. Supreme Court, that it is that entity created by law of intellectuals sitting on top of a hill that is untouchable. And I believe what we need to do in the judiciary is to do our own public relations and to make ourselves more publicly visible. I understand the court is already contemplating that by holding session in various parts of the state, and I think it's a good idea, but I think perhaps we need to go further and, for example, do a Roosevelt fireside chat, if you will. But I think it's the public's perception that needs to be not altered, but better understood.
Do we have any other questions? I think we're questioned out this morning. We really appreciate you coming this morning, and we wish you the best of luck.